Property in a divorce in California, if it is community property, which most property in a marriage is, it's to be divided equally at the discretion of the court as to how each asset is actually divided. There's no bias towards either spouse. Each spouse has an equal right to their equal share of the community property. Property division issues in California are very complex because we are one of the 14 states in the United States that's community property state, and there is this notion of community property, separate property, and quasi-community property. Without appropriate counsel, it is very possible that one party may make a mistake in determining what their fair share of property, whether it be community separate or quasi-community, actually is. In division of community property in California, the family home is often the primary asset. The difficulty with that is you obviously can't split a home in half. That's when community property versus separate property and quasi-community property issues can be very important and in need of an expert's analysis of whether there may be separate property claims to that home that allow one party to retain the home for the children post-dissolution. If you own property prior to marriage, it can affect the community versus separate property nature of that asset, and therefore it's important to get appropriate counsel to make that determination as to what part of that property is yours as separate property and what part is to be shared with the other spouse. In determining which spouse gets which asset, the court looks at which asset may be necessary for that spouse, either for their living or for their work or for transportation, and makes a determination in trying to make equal division of the property and allocating the appropriate asset to each spouse. I've been handling property division cases for 25 years and have gone to trial on property division cases and have dealt with many settlements and contested hearings on the division of community property and separate property. California recognizes prenuptial agreements, and if they're in compliance with the family law code, they are enforceable in California, and they can greatly affect how property is divided even after a long-term marriage. While prenuptial agreements, if they're done correctly, are difficult to challenge, it is often the case that they have not followed all the requirements of the law and may be challengeable depending on the facts. There's always a danger in representing yourself in a property division case in that you won't understand all the subtleties of separate property versus community property, and what we have also in California is quasi-community property. For example, if you inherit money during your marriage, that may be your separate property depending on whether it's commingled or not. In California, there's no bias towards either spouse in the division of community property, and each spouse is to receive 1/2 of the community property.